Hi everyone, are you ready to be greeted by armed USCIS special agents when you go for the benefit interview? From October 6, 2025, the USCIS special agent will be authorized to carry weapons. I'm Mohammed Amir. I'm an immigration attorney and founder of Amir Law Firm. Before I start, let me remind you that this channel is dedicated to provide you with immigration news updates and information. Please subscribe and join our growing community of subscribers. Also hit the bell icon so you can be notified as soon as a new video is posted. In July 2025, Director of Homeland Security delegated significant powers to the Director of the USCIS. We have done a very detailed video on this. If you haven't seen it, I would recommend that you check it out. The USCIS has been the agency which adjudicates applications, and the CBP and ICE are the agencies which are the enforcement arm of the Department of Homeland Security. But with this recent delegation by the Director of the Homeland Security to the USCIS, now that the USCIS has significant enforcement powers. Those powers include but not limited to issue expedited removal orders, issue detainers, issue arrest warrants, arrest and release the individual on bond, investigate civil and criminal violation of immigration law, investigate immigration violations. After that memo and this delegation of enforcement powers to the USCIS was a huge thing. It was a huge policy shift. Think of it this way. Before this delegation, generally, if any benefits that you want to apply, you would go online, print out the application, attach some supporting documentation, and apply. And the USCIS officer will review the application, and if they think that its application meets the merit, they will approve it, or if they need some further evidence, they will issue a request for further evidence, or they will deny the application. Some of you, once the denial comes, that will be the end of the road, and some of you will try to appeal it and file a motion or things like that to fight the decision. And now just imagine that you filed for a marriage-based application. Just for example, you are called in for the interview. During the interview, if the officer suspects that there is a fraud or there is a misrepresentation, the officer may not only deny your application, they may issue an order for your arrest because they have a power. They have officers carrying weapons, handcuffs, and they are given enforcement power as well. So they can just go ahead and execute. Once the person is detained, if the person has entered without inspection, they don't even have to bring them to the court. They can put them in an expedited removal process and they can remove them from the US. So this creates a very serious situation for a lot of applicants. They are already very nervous when they go for the interview. I mean, we have been to numerous interviews with the clients even before this shift of policy. And generally the clients and those non-immigrants, they are very nervous going into this all official environments and going through all the oaths and all the checks and everything. Generally, even if you are rightfully qualified for a benefit, you still get nervous. But now with this new policy shift, and it's just changing every day and getting strict and strict, I can imagine that how nervous a person is going to be. Just think about it, that you walk in, you went through all the security and the checks in, and then you get to the waiting room and you just see armed officers. They are walking around with the handcuff, and you are being greeted by an immigration officer who's going to take you to the interview room. And you will see there in the hallway, their armed USCIS officer are walking around. So it's understandable that how clients are going to be nervous, and because you are worried that if one way or the other, you may not even get a chance to appeal. And particularly the clients who are not being represented by the law firms or the attorney, they are even more serious situation. Because let's say if your application is denied and the officer suspects that there is a fraud, there is a misrepresentation, or there is some serious issue involved, and they can have you arrested right away. And if you are detained, you can be put in an expedited removal. And once that happens, you may not even have a chance to communicate or retain an attorney. So it's becoming difficult and difficult. And particularly with this shift in this policy, and this policy is getting strict and strict, it makes a lot of applicants who are applying for these benefits, whether it's a green card application, whether it's a naturalization application, whether it's an asylum application, parole application, any of the employment-based applications where now the interview is being required. It will make those clients very nervous. But on the other hand, if you think of it in this way, that the government is going very hard on the fraud and the immigration violations. Right now, the Department of Homeland Security, they have a tolerance policy for fraud, misrepresentation, or any of the immigration violation. So they are justifying their actions because they want to ensure that nobody's taking advantage of U.S. immigration regulations. No one is being rewarded for their unlawful presence or violation of U.S. immigration laws. At this point of time, the USCIS and the U.S. Department of Homeland Security, their focus is very clear that they will not allow any person who has violated U.S. immigration law to get benefit of the U.S. immigration law. They don't want to reward those people, but they want to punish those people. So on the both sides, the arguments are very strong. But nonetheless, this is going to be the new rule of law, and we have to wait and see how the USCIS is going to enforce these new rules. At Amir Law Firm, we guide our clients through these evolving requirements, ensuring their applications are complete, credible, and compelling. Thank you.